Most couples only think about family law when it's too late, when emotions are high, assets are tangled, and the word separation suddenly becomes real. But what if understanding the legal side of relationships before things go wrong could protect everything you worked for? Your home, your children, and even your peace of mind.
All of our clients, or the majority of them, have the worst time in someone's life. Financially, emotionally, people losing their assets. For me, it's very much about making sure that everybody has access to justice. I'm really passionate about that.
In this episode, we hear from Nadine Udorovic, managing partner at Nicholes Family Lawyers, who spent nearly 2 decades helping families through some of the most difficult chapters of their lives. For Nadine, family law isn't just a profession, it's personal. Her late father, John Udorovic QC, founded the firm 20 years ago, and his legacy of compassion and justice continues throughout the work she leads today. We'll unpack the legal realities most people overlook, like when a relationship officially becomes de facto, why binding financial agreements or prenups are making a comeback, and how to protect inherited or gifted assets before they are at risk.
Coming to see lawyers earlier rather than later is often a good thing. So I think for anyone out there listening who thinks they might be in a de facto relationship but is not sure, it's probably a good idea to come and have a chat, get some advice as to, well, yeah, you probably are in a de facto relationship, and if you are, this is what you could think about to do to protect yourself.
If you've ever wondered when love becomes law or how to prepare for the financial and emotional side of separation, this conversation offers clarity, empathy, and practical advice from one of Victoria's leading family lawyers. Now let's get into it. Welcome, Nadine. Thank you for joining us today. How are you?
Yeah, thank you, B. I'm good. Thank you so much for having me. I'm thrilled, and hopefully I can provide some great insight into family law for our listeners.
Yeah, beautiful. Now, before we get started, why don't you give us an introduction about yourself, who you are, and how you've come to practice law, I'd
love to. My name's Nadine. I've got 2 children. I work full time at the practice. I've actually been here for coming up to just 20 years. So we're actually, as a firm, for myself and managing partner and the rest of the team, about to celebrate our 20-year anniversary, which is really exciting. So we're having a lovely party in a couple of months to celebrate, which will be great. And for me, there's a really lovely story behind why I do what I do and how I came to do family law. So my late father, John Udorovic QC, he was a family law barrister, very successful, and was appointed Queen's Counsel at the young age of 40. And I was lucky enough to be able to work with him for a couple of years before he passed away. And he passed away from brain cancer, which was really a really tricky, difficult time. But I guess his legacy really does live on within the firm. And he opened the firm 20 years ago. So whilst he's not physically with us, the presence is definitely felt within the office. It was something that I always saw as a really young girl. I used to see Dad walk around with his briefcase and work late at night, and always had briefs and was always reading cases and so forth, and would talk to me about the work that he did and helping people and wanting to make a difference in people's lives. And I think for me, that was the start of it from a really young age. And then followed in his footsteps. I did my arts degree, and then I went on to do my law degree. And when I was studying law, instead of using the law library at uni, I would go into his chambers, and I would work in the chambers, and I would spend a lot of time around him and the other barristers, and read the law books, and I would basically study from his chambers here in the city, which was really fun. I got to know lots of people that I still work with today. And then I went on and did my articles when I graduated, and I was really lucky to have my dad move my admission at the Supreme Court. So that was a really touching moment for me, and that was just before he got sick. And I've, been here ever since. So 20 years later, I'm still here and still loving what I do. And the big part of it for me is really being able to help people and families when they're going through a crisis. And that's not lost on me, that it's often for all of our clients, or the majority of them, the worst time in someone's life. Financially, emotionally, kids are going here, there and everywhere. Money's being going in different directions. People are losing their assets. They're concerned about their livelihood, their children, their future, etc. So for me, it's very much about making sure that everybody has access to justice. I'm really passionate about that. I think that's really important. We'll always do our best to find a way to represent clients. We do a lot of work in the pro bono space as much as we're a privately funded law firm. I think it's really important that all lawyers should do some level of pro bono work, and we do a lot of it. So really proud of the fact that we can do that. Really just being able to help, individuals and families, do our best to try and keep the family unit intact where we can, and contribute to a solution for our clients who, really need guidance and support through the process.
Yeah, that sounds beautiful, and it sounds like you're continuing the legacy of your late father. And
yeah, I am, and I'm really lucky because I get to still work with a number of the more senior members of the Victorian Bar who practiced with my dad. Many of the judges in our jurisdiction, a few of them were in chambers with him together, and they worked together as lawyers, and now they're members of the judiciary, and I still get to see them from time to time. So that's really lovely. It's very comforting and humbling for me. Our boardroom at the practice here has been named the John Udorovic QC room. So it was named after him. So that's there's a really lovely plaque. So every day I walk in, I get to see that. So it's a really nice memory. It's a great legacy. So, and one that, I'm continuing on. So, hopefully making him very proud in the process, which is important.
I'm sure he is, based on what you're describing so far. It sounds like a great legacy to have. One of the things that I've seen is that in family law, it tends to be very sort of a multidisciplinary approach, because there's assets involved, there is mental health involved, there's psychology involved, and there's financial planning involved, and I dare say it's one of those few law professions where you have to work very collaboratively with everyone involved, isn't it?
It's very true. And also I think, whilst we're family law specialists, we do have a lot of crossover in other areas of the law, whether it's wills and estates, corporate, commercial, contracts, employment, etc. So we're often exposed, or criminal, for example. So we're often exposed to lots of other areas of the law. And whilst we're family law specialists, I guess we do have a level of understanding of how the other aspects of the law work. But in terms of obviously the way we practice, it is very much a multidisciplinary approach in the majority of files. So whether it's a property case or a parenting case or both, there's a team of experts that we call upon to assist. And whether that's a financial planner, an accountant, tax accountant, forensic accountant, valuers, mental health professionals, whether it's from psychology to psychiatry, counselling, and that can be for the parties and the kids as well. There's lots of different aspects that we call on. Sometimes we need a criminal lawyer to advise on an aspect. So it is a very unique, I think, area of the law where there's a lot of crossover as well. I think to provide the best level of service that we can to our clients, we very much stick in our lane. We're family law experts and don't claim to be anything else. And I often refer to it as like when you've got a medical issue, you've got your GP, you've got your doctor, your surgeon, your nurse, your specialist. It's not just
allied health as well. Yeah.
Yeah, absolutely. And it's not dissimilar for us, because we've also got then the alternative dispute resolution aspect. So the ADR, whether we need mediators and, other sort of mental health professionals for family dispute therapy and all those sorts of things. So not dissimilar. I say, look, it's a team approach. You've got your solicitor, you might have your barrister, and then you've got all the other category of people that you need to help you get through this process. So yeah, and it's interesting because it keeps it every day is very different, and we never know what's ahead of us.
Yeah. So the way I think a lot of people view family law is that they don't really talk to a family lawyer until they're in crisis, which is a very interesting component, because I guess in Australia, the idea of the American term, a prenup or a binding financial agreement, is not as common as it should be. And I feel like a lot of people, when they think about family law, it's just we only approach them when we're in crisis, whereas there's very little prophylactic approach to these things. Is that your experience, or?
Yeah, I mean, look, I think it is, and often, it's a fight or flight mode when clients come in. But I have seen, and I think industry-wide, the concept of these binding financial agreements, or if you like, the prenup or postnup, the American terminology, they've come back into, if you like, vogue again. They were very popular when they first came into legislation, and then I think they became a bit less popular at a particular time. But my reading of it is, I think a lot of it is also post-COVID, where you've got a lot of young couples who have been given, whether it's gifted or inheritance or funds that have come from one side of the family. There's a whole category and class of people that we're seeing who are wanting to asset protect, if you like, in the event that, something happens in the relationship, and really the BFAs are the only way that you can do that. So I do think I've seen an uplift in request for those sorts of binding financial agreements, particularly since 2020. And there's a lot of them that we see. And also I think the other categories, the younger couples, but then the older couples who are probably having their second relationship, and they've probably got adult children. They might be going through the second or third divorce or separation, and they want to protect themselves. And I've actually had a couple of clients, interestingly myself, who have gone through the first divorce with me and often say, I'll never get married again. I'm never going to meet anyone again. And I say, look, never say never. I'm sure you will. And then lo and behold, a couple of years later, I've had a few recently come back to me and say, look, really good news. I've met someone. I'm really happy, but I need a prenup. Because they want to protect themselves to avoid having to go through that all again, and also making sure that where they do have maybe adult children or children, and they know they're probably not going to have a family together again with their new partner, they're not going to have any more kids. They also want to make sure that, things are in line and protected for their, offspring. And that's, perfectly appropriate and understandable. So they're very much fashionable again. They're we're seeing and using them a lot more. Yeah.
Okay, beautiful. So I guess let's talk about that binding financial agreement first before we but before we get into that, let's just talk about what how the the entire spectrum of what a family lawyer does before we go into the individual components. So you mentioned there's the binding financial agreement. What sort of, it sounds like that can happen at any stage of a relationship.
Yes.
Yeah.
Yeah.
And whether it's a de facto or, yeah.
Yeah. So effectively, binding financial agreements can be used by same-sex couples. They can be used by de facto couples, and they can be used by married couples. And there's effectively 3 key times where you might see a BFA come into play, and that is either prior to a relationship, during a relationship, or post a relationship. So where we use the term prenup, that's obviously pre-relationship.
Or pre-marriage in the US.
Pre-marriage or pre-de facto relationship. And then you've got the post-nup, which is during the course of de facto relationship or marriage, where the parties decide that for different reasons, that they want to have a property settlement effectively in advance of a separation. So knowing that if they separate, how are we going to divide our assets? What are we going to do here? And then the ones that we otherwise typically see are when parties have actually separated and they are working out what their financial settlement will be. A binding financial agreement can be used to document that settlement. But generally speaking, the BFAs that we see at the end of the road, and that is after the relationship has ended, one of the benefits of having a BFA can be strategically, they can be used to waive spousal maintenance for all time, whereas a court order can't do that. So there's a bit of a sort of at times strategic benefit to having a BFA in a class or category of settlement documents. But I think what we're talking about here today is really asset protection. And how do you use a prenup or a postnup to protect your assets? And it's really the only way fundamentally that you can actually asset protect in the event that you separate, so in advance of separation. And, both parties have to be legally represented. And that's something that often a lot of people don't appreciate. They think that the one lawyer can act for both parties. So both parties need to be separately, independently represented, and they both need to receive a very detailed written letter of advice, explaining to them really what the advantages and the disadvantages are. Because what we're being asked to do as practitioners with those type of prenups or postnups is we're being asked to effectively look into the future and in some respects crystal ball gaze a little bit. What would the court likely do? There's obviously lots of different contingencies and outcomes that can occur. So they are a very effective tool, if you like. And so long as both parties are legally represented separately, and the agreement's, signed and the advice has been given, there's been no duress, and there's been financial disclosure, they're tight, they're watertight and they're binding. So they are a very, very effective tool for asset protection.
Okay. So it sounds like you need to have two independent family lawyers draft that up.
Correct.
And
yes.
When you mean independent, that has to be a completely different firm, or it just has to be a different person?
Yeah, completely different firm. So whilst at Nicholes Family Lawyers here, we've got 5 partners. We couldn't have a case where 2 partners of the firm were acting for 2 of the parties in the same relationship for this type of agreement. It has to be independent. So it would have to be a separate firm. Yes. Yeah.
Yeah. And in that sort of independent relationship, can one lawyer recommend someone or give them a list and then they go off? And is that how it often works?
Yeah, I actually do that a lot of the time because we've all got different practitioners that we work really well with. And I think it's important that the legal practitioners can get on in all cases because it often makes it just much easier for the parties who are litigating. The worst thing is when the lawyers are not getting on as well as the parties. That makes things a lot more difficult and tricky.
Confrontational. Yeah,
absolutely. And if you can pick up the phone and talk to the other side's lawyer and nut out the issues and talk about, what should happen and what will work and what won't work, I think it makes it a lot easier. So I have a bit of a list of preferred practitioners who I work really well with, and we often cross-refer these sorts of matters with each other. That's perfectly fine to do that because as long as the other party independently makes their inquiries as to who they want to represent them, there's absolutely no issue with that. It's fine. Yeah,
awesome. So, that leads to the question is, in your experience, who are the people coming to you? Because, is it I'm talking about a heteronormative relationship. Is it often the man or is it the woman coming in, or is it more related to the higher earning person, or where does that come from?
I've got a cross range of clients that come in who want these sorts of agreements. So it's probably 50-50 in terms of male and female, and also in terms of the party that's got the superior financial position. It's often easier to advise the party who's got the superior financial position and who holds all the assets, because the party who doesn't, it's a bit trickier at times to advise them because ultimately they probably carry more risk in terms of signing off to something, at a very early stage. Because really how it works is the longer that parties are together, the greater your respective contributions are. And generally speaking, the longer a relationship, contributions are often assessed at 50-50. the shorter relationships, there's more emphasis on contributions and who does what. So when you've got a young couple, for example, who come to you and say, look, we want a prenup, we've only been together for a year or so, they might be together for 30 years. We don't know. And if we're being asked to advise on, well, what's an appropriate outcome in 30 years' time? Well, what's going to happen in 30 years' time versus 5 years' time? The advice is very different because the contributions will be very different and the legislation provides for that. So often, as I said, the party with the no assets or is the one signing off to maybe not receiving very much. They're a harder client to probably advise, not to say, I mean, we do it all the time. We're skilled in being able to do that. I think as well, so it's, as I said, it's the young couples who have either inherited significant funds or have been gifted funds from their family to purchase a property or have been given money that's gone into superannuation or, for example, have accumulated their own asset pool and have a much higher earning capacity than the other party, and they want to protect themselves. The other class of clientele is, as I said, I think the older couples who, when I say older, I don't mean like elderly, but the older couples who have maybe on their second or third relationship and they want to protect themselves from going through court process or something again.
It's certainty. It's certainty because that uncertainty wrecks people. Yeah.
Correct. Yeah. And the other interesting class of obviously clientele is probably parents who come to you and say, look, I've got, 2 or 3 children, and we've gifted or we're about to gift, it's like a pre-inheritance style of, money to buy a house or something like that. And they want to make sure that their kids are protected because their kids are in relationships or they are, entering into a relationship or something like that. So
yeah, that I've seen some really, or I've heard of some cases where that's gone really awry, especially when you're buying a property for a child and then they separate and the partner separating says, well, I deserve half of it because you got that after the relationship.
Yeah. And it's often in the pool as a matrimonial asset. The question is, well, what was the contribution? And where did it come from? And then how should it ultimately be divided? But without a prenup or a postnup, it's all up for grabs effectively because there's no asset protection in place. And often as well, like I think as well, because we've got an aging population, there's a lot of people in their 20s, 30s and 40s whose grandparents are passing away, who have got significant wealth that they're handing down to not only their own children, but to their grandchildren. And I've had a few cases like that where the grandparents have actually made significant financial gifts to their grandchildren. And then the grandchildren being in their 20s, 30s and 40s, they haven't had kids yet, but they're in de facto relationships. And they want to, no doubt, and appropriately protect themselves. So that's obviously, they're probably the main examples of what we're seeing.
Yeah. So from the asset protection perspective, I mean, before, I guess, we mentioned de facto, a lot of times, and we also talked about marriage. I think that's the two terminology. I think a lot of people don't understand exactly what that means from a legal perspective. And, I think one of the, I remember watching this, podcast by this American divorce lawyer, James, Sexton. I think he's the one that's going on YouTube doing a lot of these family law conversations. And he literally said, marriage comes with a whole book of legislative things, and nobody actually gets advice on that. Basically, when you sign your name on the marriage certificate or even get yourself onto a de facto relationship, there's a huge amounts of legislation that comes with it. And, we're not teaching people about that. And there is very little advice given before they sign on one of the biggest contracts you can imagine.
Yeah, absolutely. And I think as well, I think the de facto element can often, it's often a bit more complex because
it catches people. Yeah.
Correct. Because when people get married, well, it's obvious. You got married on a certain day, you've got a marriage certificate. So it's very easy to determine the length of the relationship or when that relationship was solidified. But with de facto relationships, I've had a lot of clients who actually didn't even realize that they were in a de facto relationship, believe it or not. So
let's break that down. What is the legal definition of a de facto relationship?
Yeah, so essentially it's a relationship between two parties who are effectively living together in a genuine or on a genuine domestic basis. And the legislation talks about a sort of minimum 2-year period. Now, it's a little bit grey because there are many circumstances where parties don't necessarily live together specifically for a consecutive period of 2 years, but they could still be considered to be in a de facto relationship. So there's other considerations and other categories that the legislation talks about and the court look at. And there are things like, for example, if the parties have had a child together, it generally means that you'd be then in a de facto relationship. And sometimes people have children well before the 2-year mark. So whether there are children of the relationship, the other one is intermingling of finances and financial contributions that you are making towards the other party. I guess the other one is the way that you represent yourself to the greater public, so to your family and friends, because there are some situations where one party might think, oh, look, this is not really a serious relationship. This is more like a, girlfriend, boyfriend dating scenario, whereas the other person might actually genuinely think, no, this is a very much a committed relationship. So that's where the benchmark is, living together on a genuine domestic basis, and looking at, well, what was the length of that? And what was the sort of financial relationship between the parties? Did they have a joint bank account? Who was paying the bills? Were they sharing the bills? What were they representing themselves to the outside world, to family, friends? Was the mail all being directed, your mail? Things as simple as, I've had a few cases where we've had to really do a deep dive into, well, where was the mail going? Because often what people might say is, well, yes, we're in a de facto relationship, but it was a very short de facto relationship. And the other party says, well, no, it was a much longer de facto relationship, because the longer it is, presumably they might think that they're entitled to a bit more. We then have to do a deep dive into, okay, well, let's break that down. What does that look like? When did you live together? Where were you living? Was your mail going to that address? Were you both on the rental property? So they're all very different. That's quite interesting, the de facto legislation, because there's also a category sometime of cases where you might have a married couple, and you might have one party who has decided to have a extramarital affair, and they may have thought that it was just an affair, but they're actually in a de facto relationship. And the mistress, or the other party, if you like, is potentially able to make a financial claim, even though there's also a wife. So you've really got to look at the circumstances of the relationship. And so there's a lot in it. So I always think, and I think as we were talking about before, coming to see lawyers earlier rather than later is often a good thing. So I think for anyone out there listening who thinks they might be in a de facto relationship but is not sure, it's probably a good idea to come and have a chat, and, get some advice as to, well, yeah, you probably are in a de facto relationship. And if you are, this is what you could think about to do to protect yourself. Or you're probably not yet at that phase of it being considered a de facto relationship.
Yeah. That's very romantic, isn't it?
Yeah, probably not. But, trying to obviously get ahead of things earlier can often be, a better outcome for parties involved.
Yeah, absolutely. I mean, that sounds like, if you're in a relationship with someone over, I tell people over 12 months, you need to consider whether you meet that almost legislative threshold to be considered de facto relationship or not.
That's correct. Yes.
Yeah, it sounds like we really need to find out at what stage you end up being a de facto relationship. And I've actually seen one example where someone was married overseas and they've come into Australia, and because there wasn't, I think they came from China, and the marriage wasn't registered in Australia, the length of that relationship became very arbitrary. And in this situation where the male in this relationship then went back to China for a period of time, that had implications on when the duration or when the separation happened, and it caused all sorts of financial chaos.
Yeah, I have seen that. And I think as well, I mean, look, people are moving around a lot too. So, I see a lot of clientele who, for example, one party might have a job where they travel a lot. And they might be based overseas for significant periods of time. Now, that doesn't necessarily mean that you then stop the clock for every period of time that person has been out of the country. I have had cases where the other side have tried to use that as sort of a mechanism to say, well, the de facto relationship is very, very short because one client was, out of the country working for months and months and months and months on end. But, I mean, that doesn't necessarily mean that you do stop the clock, because you don't stop the clock in a marriage just because someone might be traveling or holidaying or whatever it might be. So, because you could still be making contributions to a relationship, to a person, even if you're not physically together.
So I guess we talked about starting the clock in a de facto relationship. There's also that, when does it formally stop in terms of a relationship? I guess that's also the other question.
And that's a really good point, because one of the first questions I have for my client, if they come to me and say we've separated, I'll say, okay, well, what was the date of separation? And surprisingly, a lot of people don't know, and they say, well, what does that mean? Well, explain to me. So generally speaking, I would always advise that a date of separation is probably the date where there's been some form of communication from one of the parties to the other party that either the de facto relationship or the marriage is at an end, and that they want to go their separate ways. That is often aligned with maybe parties moving out of a matrimonial bedroom and going into separate rooms, or one party vacating the house. It's not always as clear as that, but I would always think that there has to be some formal recognition or some formal note, whether it's on an email or a text message or a conversation, but the other party needs to have been communicated that, well, we're now no longer a couple. We're now no longer in a relationship. But surprisingly, a lot of people, that may not have been the case. They've just sort of slowly drifted apart. They may not have actually had that big conversation. And so if they have just drifted apart, some of the things that we look out for is, okay, well, if that was when you started drifting apart, did you stop cooking for each other? Did you stop going out together? Stop doing your laundry? Like, it's as simple as that. How were you living in the house together? Did you talk? Did you eat dinner together? It's those sorts of things. So it's not tricky. It's not complicated. It's pretty straightforward. But it's doing a deep dive into, well, how did you then, if you think that you, for example, separated in September 2025, but you didn't actually have a conversation, well, explain to me what that month looked like. What were you both doing? How much time did you spend together? Because for a lot of couples, they don't necessarily, actually communicate it. It's communicated in different ways. But we always, obviously, if there's a marriage, there needs to be a clear, defined date of separation for the divorce to take effect. But even in a de facto relationship, we still need to know effectively, even if we can't pinpoint it to the day, well, what month was it? Was it September 2025? Was it, January 2025? Because often those months can make significant difference in terms of a financial settlement. When we're looking at what was happening with the asset pool, what was happening with the party's income, was there an inheritance received? So when was that received? When did it come in? Was it pre-separation or post-separation? So the separation date as the starting date of a relationship, both dates are very important.
Yeah. And I mean, this sounds a bit cliche, but that could be just communicated, as you mentioned, through a SMS in a way.
Yes. Very non-romantic. But
None of this is. And my question to that is that, does the other person then have to say, yes, I have received this message and I acknowledge this? Or is this, can you send it and assume they received it?
Yeah, so they don't have to acknowledge it, because surprisingly, there's a lot of people that don't want to acknowledge the end of a relationship, or don't want to get separated, or don't want to get divorced. You can't stop that happening, which is quite sad and, unfortunate, but that just is what it is. If one party's out, then that's it. I think, the verbal conversation is probably a bit harder to prove. If an email's gone through and a text message has gone through, you would expect that, unless there's been a power outage or whatever. If it's been sent and it's gone through and there's been no bounce back, it's been received. When it was received, well, if someone doesn't access their emails or whatever, but no, the other party doesn't technically have to acknowledge it, because, in some instances they don't want to acknowledge it for different reasons. And they can't come to terms with the fact that, the relationship has ended. But a clear definition of when it starts and when it ends is important. And it's probably, more aligned to financial ramifications. But it can also have impact where there's parenting disputes at play as well.
Yeah. I mean, the kids side of things, I think it just adds a whole lot of complexity into that. And, but it's really good to know what's the definition of a start of a relationship, because that can be precede a marriage. And in fact, some people may never choose to get married, but they're still obviously locked into that, de facto relationship status. Yeah.
And I'll give you some overview of that, because a lot of the time you do see a very significant period where people are dating. That doesn't mean you're in a de facto relationship, and you could be dating someone for many, many, many years. But if you're not technically living together and or then making, financial contributions to each other, or haven't had children, or you're really just boyfriend and girlfriend, you're dating, the clock is not started yet. So there could be a very long period. And sometimes in that period, there can be a significant inheritance or...
So what about, you say that's a bit nebulous when the clock starts. I mean, marriage, obviously it's that's a fixed time. There's no disputes about the time of that starts. What about if you were in a de facto relationship? You're not technically de facto. Sorry, you were in a relationship. You're not technically de facto, and one party falls pregnant. When does that?
Well, so so if you were then, living, if you then moved in together, you'd probably start the clock ticking from that point in time. But then obviously there are some situations where one party's pregnant and the parties don't live together. I think from that point when the child is born, you would then, as long as the parties are still actually together and they don't separate, then think, okay, well, we're now in a de facto relationship, and presumably at some point they're going to move in together and start their life together. But I've had a few cases where young couples have just, accidentally, if you like, fallen pregnant, and they haven't ended up staying together. So there was really never any significant de facto relationship, even though it might be a de facto relationship. They weren't really together for very long. So you can sort of gather they're all very case specific. They're all, every family and every relationship
different.
is yeah.
And a modern family is very complicated nowadays. Yeah.
It's very complicated. Yeah. And so whilst we've got the legislation that we use as a guideline, there's also lots of case law that has, that goes with that is specifically looking at different issues, that we also have to refer to, when we're assessing.
Yeah. So it sounds like, these are the I guess milestones which will push a relationship into a de facto, is that if they are living together, they start sharing financial sort of contributions together. If they end up having a child at the birth of the child together, that's also another point. And obviously, the big one is that if they sign on the dotted line and they're registered as a marriage, that starts.
Because a lot of couples are together in a de facto relationship for a number of years and then they get married. So then we don't just look at the length of the marriage. We add on the length of the de facto relationship to the relationship period. Yeah.
Yeah. And in your experience, because you've been doing this for 20 years, do you find that that's becoming a bigger, a bigger and bigger component and consideration, that de facto period? Because relationships are changing, obviously.
Absolutely. And a lot of couples don't want to get married at the outset, and then they might be together for 10 years and then have kids and decide, well, we want to get married now because we've got a family. But you've still got to add to the length of the relationship that de facto period. And it's often really important from a financial perspective when you're looking at, well, how long was this relationship? Because as I said, the longer a relationship, the greater, contributions that both parties are probably making, both financial and non-financial. So with the passage of time, there's more weight there because the relationship is a longer relationship. So you've done more for each other and for the relationship because it's a much longer period of time.
Okay. I think we've talked quite a bit about the time period of the relationship. Now we're going to get into the really unromantic part, is in terms of separation, and how do the courts, view that process? We've talked about the length of time, the asset contribution, whether there was a binding financial agreement in the process. But when it ultimately comes to the end, what does that process look like? Yeah.
Yeah. So I'll give you, so in terms of an actual divorce, so for parties to apply for a divorce, you need to have been separated for 12 months. That's a minimum period. And then on the one day after the 12-month period, you can apply for a divorce. So you can't seek to be divorced previous to that. And that's really just a, sort of technicality, and that's pretty straightforward.
Yeah. It's like a cooling off period, isn't it?
It's a cooling off period. Because look, for a lot of couples during that 12-month period, they do reconcile. For different reasons, or they might be having couples counselling or relationship counselling, and sometimes they just need a bit of respite from each other. They need a bit of time to just decide, do we really want to stay together? So I guess it does give that period where then they can really determine, look, is this the end, or are we going to reconcile? So that's the divorce side of it. But from the point in time where parties separate, at any point thereafter, they can apply for a financial settlement. So if they don't have a prenup or a postnup in place, if they need to go through the other avenues of applying for financial settlement or working out a financial settlement, you don't need to wait the 12-month period. You can do that straight away.
Okay, from the point you have that financial separation. From the separation. Okay.
Yeah. And sometimes, a lot of people want to get it done really quickly. They don't want to wait. They've come to the realization it's over, we're not reconciling, and they start the process pretty early. And I think, what does that look like? So for us, the starting point is meeting with the client, working out what is in the asset pool. So that's normally the first question. Okay, well, tell me what is on the balance sheet. What assets do you have? What assets does the other party have? And then we sort of look at that. We work out whether or not assets need to be valued. So that could be real estate. It could be business interests, other entities. We look at superannuation, all those sorts of things. So shares, cash investments, motor vehicles, everything. And we start the process of financial disclosure, because often the disclosure part of it is a really big piece. And then once we've gone through the working out what's on the balance sheet, having everything valued, disclosing all the information, exchanging all the information, the next step is to work out, well, what's the right process to resolve this? And one thing that I very much advocate for is the alternative dispute resolution process, so ADR, to avoid court if we can. And that can look like collaboration, mediation, roundtable conferences, etc. So there's lots of different layers to alternative dispute resolution. Some cases do really need to go to court as well, and sometimes it's not a bad thing. So court's not always bad. So sometimes it's appropriate that we have to go to court because we can't get the disclosure that we need, or the other party won't agree to it, or they won't agree to valuation. So we need to go to court to get subpoenas and get orders for things to happen. Or, you might find that funds have been misappropriated. Significant cash has gone missing from the bank account, or a property gets sold and the other party doesn't know about it. So, in those instances, we need to get injunctions. We need to seek restraints. And that would be an appropriate, step to take through the court process. So we either sort of go down the litigation path, or we go down the more sort of alternative dispute resolution mediation path to resolve financial settlements. So there's sort of two ways that we can do it.
Yeah, and I guess we can talk about the different forms of that in a separate episode. But like in terms of that, what's your experience in the proportion of that happening? Is that, do most go to court?
I think it's 50-50. I think that, we've got, there's lots of litigation, but there's lots of, other ways of resolving financial cases. So probably if I look at the firm as a whole, it's probably 50-50, maybe more towards the ADR side, which is probably good. There's probably 1 or 2% of cases go to final hearing. So that is all the way to a final trial.
So that's tiny. Yeah.
That's tiny. Yeah. Which is good. Because, generally speaking, I often say, look, the cases that go to trial, it's often not about the case. It's about who's involved and the personalities. It's not always about the law or the legislation. Look, there are those cases that, are very complex, and they have to go to a final hearing. But the majority are probably because the parties are just so misaligned, and there are significant issues at play that they go that far. Because with the court process now, there's so many steps before you get to a final hearing. You've got about 18 months to 2 years, if not more, sometimes a bit more less. So there's a lot of opportunity to resolve a dispute, and the court make you have a mediation anyway. So you don't actually have a choice. So they do, enforce that on parties too before they go to final hearing. They have to mediate and try and compromise. So there's a lot of opportunity to avoid it.
Yeah. And people get sick of that process as well because it's very confrontational.
It's called litigation fatigue, and it's very real. It's actually a real thing. People get burnt out. The lawyers get burnt out. The professionals get burnt out. It can be really exhausting. And, very, very costly too, financially and emotionally.
Yeah. And in that, do you, there are instances where, we're talking about the financial settlement, but what about, from a children perspective? That's a completely different piece from the financial aspects of it. And, but if you have both matters, you run them both concurrently. They're run together. And which one is the one that causes more problems? Is it the financial of the children, or is it a bit different?
I think parenting cases are harder, to be honest, because property cases, it's numbers. There's a formula that we look at. I think parenting cases are often trickier because there's no formula for kids. And every child, every family, every circumstance is different. And obviously there's that higher probably state of emotional overlay with respect to children. And probably people in general are more complex than a balance sheet, I would say. So I do think that parenting cases are probably trickier, and I think they're probably harder because you can't split kids in half. You can't just divide them. You can divide a bank account. That's pretty easy. It's not hard. You can sell a house and you can divide the equity, but you can't split kids. So that's really tricky, and it's often trickier where you've got a really young kid and an older child and they've got different needs. And they can cope with different things. So that's really hard to navigate in terms of, well, what's the appropriate parenting outcome look like here? Because for a 2-year-old, it's very different to a 15-year-old or a 12-year-old. And then you've got the added layer of relationships between children and parents. And sometimes it's stronger with one than the other, or one child's got a stronger relationship with dad, the other child's got a stronger relationship with mum. And, you know, the parents are not getting on. And the greater family's not getting on, who are otherwise very pivotal and instrumental in looking after the kids, you know, the grandparents and so forth. So it's very layered, very, very layered. It's like I guess, peeling back an onion. It's like layer after layer after layer. So I probably think that, you know, parenting cases are more difficult. I think at the moment, you know, they're getting more difficult as time goes on. I don't know why that is. Maybe it's just society in general is more complex these days. You've got social media. I think that has brought in a whole nother layer of complexity for families and family dynamics because everything's online. So the social media can be really good, but I think it can also be really difficult in some instances. So probably the parenting side of things is getting more complex, I would think.
Yeah, and you know, personally, I feel like it's also that the family dynamics between mother and father is also very different as well, and parenting styles are different. No two parents parent the same. Absolutely, and you know, there's this whole thing about equal parenting, and whereas you know, my understanding is that previously, if you had a young child, they tend to end up with a mother because that's just the way things worked. Exactly. And so there's a lot more contention, right? Isn't it? Yeah.
Correct. Yeah, absolutely. And different considerations for little kids versus teenagers versus older kids. You've got other things that we deal with like international relocation or interstate or intrastate relocation. So parents that want to move across borders. So the movement of children. So we have to deal with those aspects. You've got cultural issues that come into it. Or simple things, for example, parents have different ideas about how their children should be educated or how they should be fed. So it's very, very layered. There's lots of things that go into it.
Yeah. I think that's we'll probably unpack that in our next episode.
That's a whole nother episode. That's
a whole nother episode. Thank you so much. This podcast is for educational and entertainment purposes only. The information and opinions shared are not intended as personal financial advice. The content presented should not be relied upon for making financial, investment, or other decisions. Listeners are strongly encouraged to seek the advice of qualified financial or legal professionals before making any financial decisions. While we aim to provide valuable and accurate information, we make no guarantees regarding the completeness or accuracy of the content. Any reliance on the information provided is done at your own risk.